All right, moving on to R1, take the following actions. Temporarily suspend the operation of Rule 7E1 in Administrative Policy 1-101, operation and conduct of business by the Board of Supervisors. 2, 3, 4, A and B. Stuart, you coming up, or are you going to do it from right there?
I'm going to do it from right here, Chair.
Beautiful.
So, good morning, Chairman Cry, members of the board, Stuart Butel, Deputy County Executive Officer. Before you today, as you noted, for your consideration are a series of actions related to ensuring that Measure P, which proposes in addition to the county charter limiting the county's ability to exercise eminent domain, can be placed on the ballot in a timely manner, with an accurate proponent argument articulated by the board. Typically, Administrative Policy 1-101 limits the board's ability to comment formally on items on the ballot. However, in certain circumstances and per Elections Code 9162 subpart A, where the board is responsible for placing an item on the ballot, Rule 7E1 of Administrative Policy 1-101 may be waived. Accordingly, the first action is to temporarily suspend Rule 7E1. The next action would then be to review and approve the draft supporting argument for Measure P and direct staff to draft a rebuttal argument in the event of an opposing argument being submitted. This would be brought back for the board's consideration at a later date. The third action requests the board to select a member of the board to assist in the final preparation of ballot arguments related to this measure. Finally, the fourth and final action associated with this item is to request the board, through the chairman, to complete the verification statement and argument statement associated with the supporting argument for Measure P and authorize staff to deliver it to the Elections Department. I would also like to make a further note and thank the Elections Department for getting these materials processed quickly and for already providing a draft calendar specifically outlining their next steps as they relate to Measure P. And it's imperative for the board to review and consider approving the supporting argument today, as it must be submitted to the Elections Department no later than August 15th, which also coincides with other requirements as set forth by the Elections Department and Elections Code. And with that, Chair, that concludes my presentation.
Thank you, Mr. Butel. Supervisor Jones.
Thank you, Chair. Would you like to be selected as the member of the board to assist and for the argument?
Yeah, with the language, yeah, Stuart did the original charter language and worked well with him, so I sponsored this, so I'd appreciate doing it again.
Okay, then with that, and since we've already discussed this, I will waste no time. Take action number 1, temporarily suspend the operation of Rule 7E1 of the Administrative Policy 1-101. 2, approve the argument in favor and adding limitations on the exercise of eminent domain of Shasta County Charter. 3, select a member of the board, which would be Chair Cry, and 4, approve and complete the verification statement and the argument statement provided by the Elections Department.
And I'll second.
Okay, so we have a motion by Supervisor Jones, a second by Supervisor Kellstrom. We do have public comment. Jeff, Susan.
Good morning. As I stated in my recent email about the eminent domain charter amendment, it seems to me that this exceeds the authority given to charter counties by the California Constitution. As far as I can tell, there's nothing in the constitutional provisions which authorize the creation of charter counties and set forth the legitimate areas of control by charter counties that would authorize a charter county to exercise control over eminent domain law. It just isn't there as far as I'm concerned. I know this board is intensely concerned about following the rule of law, and I'm sure this has been vetted significantly by county counsel's office, but I believe that this amendment would be unconstitutional. Secondly, the state of California in Article 1, Section 19, Title 7 of the Code of Civil Procedure has created a comprehensive set of eminent domain laws that leave no room for counties to make their own laws regarding eminent domain. The state has occupied the field and left no room for counties to independently legislate in this area. Thirdly, the amendment conflicts with laws already on the books regarding eminent domain. Article 1, Section 19 of the Constitution states local governments are prohibited by acquiring by eminent domain an owner-occupied residence for the purpose of conveying it to a private person. You know, in essence, the harm you're trying to address is already covered in our Constitution. However, your proposed amendment omits the exceptions that are set forth in the Constitution, and that is a local government can exercise eminent domain over private property and convey it to a private person under the following circumstances: for the purpose of protecting public health and safety, to prevent serious repeated criminal activity, to respond to an emergency, or to remedy environmental contamination that poses a threat to public health and safety. Your proposed amendment eliminates those and therefore conflicts with the California Constitution. I urge you not to put this on the ballot. I mean, the Attorney General is already aware of the excesses by this board. They're keeping an eye on this. Other private lawyers will be monitoring this as well. I believe it will be challenged in court. It's an unnecessary expense to the taxpayers, as the harms this amendment seeks to address are already covered in the Constitution. I would really ask you to reconsider this. Thank you very much.
Susan?
Yes, I wasn't able to be here at the July 16th meeting. I'm trying to have a life. I'm sorry I missed it. I'm grateful to see that Tim and Mary voted against this issue, because even your county council said that it was not within your purview to take this kind of action at that meeting. No, he didn't, Kevin? He said it. I read it. He advised you that it wasn't a good idea. Just like Jeff said, once again, we're leading a charge against the state. And then we wonder why you have so many speakers up here trying to talk to you about reasonable solutions and what you see as causing chaos. Who's causing the chaos? Who's keeping us in possible legal situations which cost us money? It isn't the citizens. Is it? You know what? From an outsider point of view, I think that you have somebody personally that needs this taken care of right now, and you brought this quickly. I know you can look at me and say I'm crazy, and I have no proof. I'm telling the audience I have no proof, but as far as I'm concerned, it looks bad.
Thank you. Council, would you like to weigh in on the inaccuracies of everything that's been said this morning?
Thank you, Chair. I'm happy to do so. Although some of the citations were accurate, digging into them a little further, I have some contradicting information. First and foremost, the board has already adopted this charter amendment to go onto the ballot, so that's already occurring. With regard to the citations, there is a California Supreme Court case that allows the legislature to place additional restrictions on the exercise of eminent domain. So far, California has failed to do so. They've had a couple attempts to place restrictions on the ballot and have the state voters enact that. That's failed. Therefore, public agencies are empowered to do so, and many have done so.
Thank you for the clarification and honesty ringing true. Supervisor Jones.
Well, and I for the two speakers, I think it's shameful. What this does is protects private property rights. And for anybody that doesn't want to do that, it's just shameful. I applaud Chair Cry for bringing this forward. And these are exactly the types of things that we'll put forward to the voters, and they will approve because they're the right things to do. The two speakers should be ashamed.
Supervisor Ricker.
I'm sorry, Supervisor Jones, that's really inappropriate to say that to speakers. I just can't, I'm going to have to speak out more. This is just getting ridiculous, the way you treat speakers. Okay, for transparency purposes, I'd like to know, evidently it was Supervisor Cry's idea, and what exactly is the basis for this? Who is behind this, and who brought this forward to you? Who brought this forward to you?
I did. I brought it forward because of what I've seen government agencies in our area do to private property rights.
Okay.
And for me, when we talk about the state of California, just because the state of California has something in place doesn't mean they can't repeal it, walk it back, and do something different. Furthermore, San Bernardino's charter, which I think is one of the best charters in the state of California, I looked at their charter and some of the things and the ways that they protect their citizens, and it seems very evident to me that this board, in every opportunity, should protect its citizens as it relates to private property rights. So, and if you oppose it, you can vote no.
Okay, I'd like to know, in the last 20 years, how often has the county used eminent domain? Has there been a number?
So I don't have that number right off the top of my head, Supervisor Rickert, but in researching this item, I believe it was just over a decade ago the county had anything to do with a case involving eminent domain. They are few and far between typically for exactly the reason Supervisor Jones mentioned, I think.
I mean, it's,
Go ahead, Chair.
So in other words, that's my point, is we are spending time, we are spending taxpayers' time, taxpayers' money for something that hasn't been happening. And I'm a private property owner a lot more than you are.
you've
And so-
done
and I-
very well for yourself, Supervisor.
Yes, I
Rickert.
have.
We all agree.
We have. We've worked very hard. And we've done it legally and everything. And I'm telling you that this, to me, is another example of time, it's time consuming. It's a lot of wasted resources and energy for something that we haven't been using. When we have, I had a presentation last board meeting. We had 58 deaths in this county last year from fentanyl. Not one of you said, this is an important issue, we need to get into it, we need to find out what's going on in our county, and we need to save our people. Why can't we get our priorities right in Shasta County? I am so tired of things that are virtually non-existent that we cover and we spend time on, we call special meetings, but we're not focusing on things that are impacting families in this county.
Thank you, Supervisor. Supervisor Jones.
Well, we know where the fentanyl is coming from. It's coming from across the border.
And how many,
Hey, this is Supervisor Jones this time.
Yep, thank you. We know where it's coming from, and it's coming from across the border, and this board took action to do something about that, which you did not support.
no,
Now,
This is Supervisor Jones this time.
in addition to that, when I was with the city of Reading, the use of eminent domain was threatened repeatedly. It wasn't used, but it was threatened. And I don't think we should be threatening our citizens for the taking of private property. And so while it wasn't used, it was threatened many times. This is a good amendment to a charter. I definitely support it.
One of the reasons that, for me, again, with, you talk about it hasn't been an issue. Well, it's much like insurance, right? Like, you never have enough until you need it. And it seems like if you
That's-
but here's the thing. At the end of the day, COVID happened, and we saw what the government's capable of.
You're shifting the subject.
Hey, I'm once again speaking. We didn't interrupt you. And for me, this is about an amendment to the charter. This is there'll be 2 amendments on this one. Again, other charters constantly amend it. So as long as I'm seated, I will bring something every single election that I believe protects people's rights, gives people an opportunity to make things more affordable, and gives them more sovereignty to raise their own family as they see fit. Any way, shape, or form that an amendment comes forward, I'm going to bring that, because it's just like this boardroom had never been locked and the public been locked out before, but that happened. So things happen, Supervisor Rickert, that I feel as a chair or as a board member, I have to protect the citizens from the overreach of government. Supervisor Rickert.
this is not an overreach of government if we haven't had a threat. And that's what I'm saying, is that we haven't dealt with this. It's a waste of time, it's a waste of money. I'm the one that's worried about the taxpayers' dollars. I'm the one, I am the one, we're spending, how much did it cost to have this special meeting to deal with this? And that's what I'm saying, is that this is ridiculous. We are having people dying. Our streets are full of people that are unhoused. And we're putting this as a priority over something that virtually hasn't happened? Think about it. Use common sense. What happened to common sense in Shasta County?
It was locked out.
I am sorry, but this is just, and I agree with Mr. Gorder. I think that this has a potential to face legal challenges, and with all the things that's going on and the lawsuits that are piling up in this county as a result of the behaviors of the board majority, this is going to be one more thing, and that's going to cost the taxpayers of Shasta County. So I am still fighting for the taxpayers of Shasta County.
It's a great speech. Stuart Butel, can you please help Supervisor Rickert understand why this is put on today's meeting and why this had to be called? And I hate to do that to you, but I'm going to say it.
So I can clarify and mention that it is critical for the board to consider the proponent argument for this item as the board majority approved putting this on the ballot. And typically, whoever is supporting a measure such as that needs to have or come up with or generate and provide to the elections department that proponent argument.
And this item was missed, so it had to be put to, or the wording. Help
That's-
me, let's clarify that.
So this particular piece, as we did when the charter was originally introduced, I had to come back last December and present an argument for the board to consider that could be added to the voter information guide. That timeline is very quickly closing, as I mentioned. Elections has to have this information by no later than August 15th, which means if Supervisor Cry is selected to work with staff on this, we'll be very quickly putting together this argument and getting it over to elections, and then this information will be added to the voter information guide. So that timeline is very tight.
No, I understand that. And you and I talked about this yesterday. So we talked about it, this whole
Great.
subject.
All right, let's go ahead and take a vote. We'll do a roll call, starting with Supervisor Rickert.
No.
Supervisor Rickard?
No.
Supervisor Kellstrom?
Yes.
Supervisor Cry?
Yes.
And Supervisor Jones?
Yes. Passes 3-1.